Jai Hind. Welcome to GS NEXUS Current Affairs series. In today's session, we are going to have a discussion on can the Lokpal prop complaints against High Court judges? Let's first know why this is in news. The Supreme Court recently issued the Union government in a suo motu case initiated against the Lokpal decision, which held that it can exercise jurisdiction over High Court judges. Earlier, the Lokpal, headed by former Supreme Court Judge A.M. Khanwilkar, based his opinion on two grounds. Firstly, the High Courts were not established under Article 124 of the Constitution, unlike the Supreme Court. Secondly, a majority judgment of the Supreme Court in the case Veeraswamy versus Union of India says that a judge of superior court cannot be excluded from the definition of public servant. The case will be heard next on 18th March 2025. Now, let's know about Lokpal and its evolution in India. The Lokpal is an anti-corruption body established to investigate complaints against public officials, including prime ministers, ministers, and members of parliaments. It aims to enhance transparency and accountability in the governance. The concept of Lokpal, that is Indian Ombudsman, was first discussed in the early 1960s with the term Lokpal coined by Dr. L.M. Singhvi, and it was introduced in 1963 by the Law Minister Ashok Kumar Sen. The first Administrative Reform Commission recommended the establishment of Lokpal at the central level and Lokayukt at the state level. The first Lokpal bill was introduced in Lok Sabha in 1968. Maharashtra became the first state to implement the Lokayukt system with the Maharashtra Lokayukt and Up Lokayukt Act passed in 1971. However, the bill was first introduced in Odisha State Assembly. Following the protests led by Anna Hazare, the Lokpal and Lokayukt Act 2013 was passed in December 2013 and came into force on January 16, 2014. Now, let's know about composition of Lokpal. Lokpal and Lokayukt Act 2013 predicates establishment of high-powered body called the Lokpal of India, comprising of chairperson, a person who is or has been a Chief Justice of India or is or has been a Judge of Supreme Court. Next is up to 8 members. Among them, 4 members should be a judicial member, a person who is or has been a Judge of Supreme Court or is or has been a Chief Justice of High Court. And another 4 non-judicial members should be a person of impeccable integrity and outstanding ability, having a special knowledge and expertise of not less than working 25 years in the subject prescribed in Clause B of subsection 3 of Section 3 of the Act. Now, let's have a look on jurisdiction of Lokpal. Section 14 of the Lokpal Act lays down the jurisdiction of Lokpal. It specifies the people against whom complaints can be filed. This includes the Prime Minister, other ministers, Member of Parliament, other central government officials and public servants. Jurisdiction of Lokpal also includes chairperson, members, officers and directors of any board, corporation, society, trust or autonomous body either established by an Act of Parliament or wholly or partially funded by the union or state government. It also covers any society or trust or body that receives foreign contribution above Rs 10 lakh. Next is about complaint under the Lokpal Act. In terms of provisions under Section 2E of the Lokpal and Lokayukt Act 2013, complaints can be filed against any offence alleged to have been committed by the public servant under the Prevention of Corruption Act 1988. The offences are described under Section 7, 7A, 8, 9 and 13 of the Prevention of Corruption Act 1988. There is no restriction on who can make such a complaint. When a complaint is received, the Lokpal may order preliminary inquiry by an inquiry wing or any other agency or refer it for the investigation by any agency including the CBI if there is a prima facie case. The Lokpal with respect to central government servant shall refer the complaints to the Central Vigilance Commission. Next is the Veeraswamy case. In 1991, a 5-judge constitution bench in K. Veeraswamy versus Union of India had held that the judge of any court is a public servant under the Prevention of Corruption Act 1988. Now let's know some additional facts. The Foundation Day of Lokpal of India was held for the first time on 16th January 2025. On this day, the Lokpal of India was established by virtue of coming into force of Section 3 of Lokpal and Lokayukt Act 2013 on 16th January 2014. In terms of provisions under Section 53 of the Lokpal and Lokayukt Act 2013, a complaint cannot be made after the expiry of 7 years from the date on which the offence mentioned in the complaint is alleged to have been committed. The first chairperson of Lokpal is Justice Pinaki Chandra Ghosh. The chairperson and members of Lokpal are appointed by President and their term is 5 years or till the age of 70, whichever is earlier. That's all for today. For more such videos, stay tuned with GS NEXUS.